Balake. Where is Balake at?
My name's Blake.
Do you want to go to war, Balake? I'm for real. Ron.
Ron is here, everyone. Welcome back for more SPTV, where every day's a great day not to be in a cult. We got an update in one of the trafficking lawsuits against David Miscavige, the leader of Scientology. Regular viewers of this channel will already be familiar with this case, but for you newcomers, did you know that a woman who worked for Scientology's leader, David Miscavige, and his wife, Shelley Miscavige, this is before she went missing, was banished to a secretive Scientology base, never to be seen by anyone who recognized her again. A woman named Valerie Haney, born and raised in Scientology, worked for Scientology's Sea organization since she was a young woman, maybe even a young girl. She worked directly for David and Shelley Miscavige. And she worked at Scientology's secretive international management base out in Riverside County, California. And one day she escaped from the base by hiding in the trunk of a car of a non-Scientologist who was visiting the base to film one of Scientology's films. Scientology's international management base has a movie production studio called Golden Era Productions. And that Gold, they call it Gold. Gold will hire non-Scientologists to be in their films. And she was so desperate to get out of there, she hid in the trunk of this car. The guy had no idea she was there. The Gold base is about 90 minutes outside of LA. And she hid in this damn trunk for the entire commute. And then when, I guess whenever he got to his final destination, she popped out, was like, surprise! Can you even imagine the shock? Okay, so even though she escaped from the base, Scientology used the leverage that it has over its members. It's the leverage of disconnection, making it so that if you don't leave Scientology on their terms, you will never see any of your friends or family members ever again. And so even though she escaped, they brought her back. They got her to come back and agree to leave on their terms, which means undergoing dozens of hours of abusive interrogation. And it also means signing all their legal documents. And so that is what occurred. Fast forward a number of years later, and Valerie Haney, who's the woman we're talking about, she sues David Miscavige and Scientology for a whole bunch of things, including various trafficking accusations. Now, in part, because Scientology succeeded in getting her to come back and sign all the forms that said she was a bad girl and Scientology was great and David Miscavige was wonderful, some of the forms that you're required to sign are these a form agreeing to take any complaint that you have against Scientology or any Scientologist to internal religious arbitration. Okay. So when Valerie sued Scientology argued that this could not move forward in the courts. This had to go to Scientology internal arbitration. The catch is, guys, there's no such thing as Scientology internal arbitration. It's a trick that Scientology made up to fool the courts to prevent themselves from being sued by angry former members. In fact, back in 2017, a former Scientologist and good friend of mine named Luis Garcia sued Scientology. And he was the first, that lawsuit was the first time Scientology ever successfully argued that this needed to be argued in internal arbitration and not in the courts. And in the process of that whole case unfolding, Scientology was forced to admit that they had never in the entire history of Scientology ever conducted a religious arbitration. Because it's not a real thing. And there's no policies in Scientology describing what this thing is or what it should look like or how it should act and all the rules and all that kind of stuff. And so Scientology and also judges are not allowed to interpret what the law considers to be religious scripture. And unfortunately, since the IRS gave Scientology its tax exemption back in 1993, L. Ron Hubbard's policies are considered by the courts to be religious scripture. And so Scientology was able to just lie to the court and say, Your Honor, L. Ron Hubbard laid down the rules for internal religious arbitration. It's in a policy letter called Committees of Evidence. And the judge is not allowed to read that policy and go, it doesn't say anything here about arbitration. Anyway, Scientology was able to convince the judge that the judge had to send Luis Garcia's case to internal religious arbitration. And that was the first time in Scientology's history they ever held one. That was in, I think, 2017. Fast forward, Valerie Haney is only the second person to ever undergo a so-called Scientology religious arbitration. Now, when they did Luis Garcia's arbitration, it lasted for 1 day. Valerie Haney has now been subjected to 5 entire days of this horribly abusive so-called internal religious arbitration. And Scientology is now, so it was supposed to be finished by now. They were supposed to be finished by now. They were supposed to go back to the court, have a status conference, explain what happened. The judge was either supposed to sign off on it or say, something don't smell right. We're going to have to revisit this issue. Anyway, so now instead of going back into the court and doing the post-arbitration status conference, they're going back into the court so Scientology can ask for 5 more days of this horribly abusive, totally arbitrary, so-called internal religious arbitration. There was a filing made by Valerie Haney's attorney, Graham Barry, yesterday. And this arbitration, this filing is basically the attorney telling the judge, hey, look, they're asking for this extra time. You need to know what has already occurred in the first 5 days. And also, we need you to tell Scientology that they have a finite amount of days within to finish this, because they can really do whatever they want. And all they're doing is re-abusing Valerie. So what I'm going to do is share with you some sections out of the filing that Graham Barry made. You can see this was filed just yesterday. Plaintiffs post-arbitration status conference statement number 2. All right, we're going to jump forward to page 4. And let's just see what Graham Barry has had to say about all this. The conduct, oh, by the way, the 5 days that Valerie has already been subjected to weren't even they weren't like even 5 consecutive days or 5 days in a week. It was like 3 days here, and then many months later, it was another 2 days. And so, yeah. Okay, it says here, reference is made to plaintiff's post-arbitration status conference statement filed herein October 24th, 2023. Except for the details of section 3, very little was different during days 4 and 5 of this forced religious arbitration. Plaintiff was again subjected to an egregiously unjust, unconscionable, and fundamentally flawed forced arbitration process, which deprived her of basic due process rights. Forced to endure this so-called religious arbitration, she was denied the opportunity to review the critical documents that the arbitration panel was scrutinizing. Initially, the arbitration panel attempted to dispute what plaintiff had described in her October 24, 2023 post-arbitration conference statement before returning to the plaintiff's ethics and pre-clear folders. Okay, I want to explain that real quick. So basically, after Valerie had her first 3 days of arbitration, she submitted a report to the judge, the court, describing it and complaining about it. And then when she showed up for her next 2 days of arbitration, the first thing Scientology did was rake her over the coals and berate her for how she described her first 3 days. They are actually, I want to say, I don't want to just casually use the word abusing her. They are essentially upbraiding her, saying it is not okay with us what you said to the court. How is this acceptable, guys? Okay, now there is a phrase here. Let's see. Before returning it to the plaintiff's ethics folders and pre-clear folders. So in Scientology, your ethics folders have all of the reports that have ever been submitted on you for being a bad boy or girl. And your pre-clear folders is your auditing files. It has all of the worksheets and the notes from all of your auditing sessions and all of your interrogation sections. Okay, it says these folders were housed in at least 7 bankers' boxes containing hundreds, if not thousands of pages in each banker's box. Moreover, specifically, as the committee was going through box after box of the plaintiff's ethics folders, they informed her that she could not have access to any of them. This meant plaintiff was forced to read hundreds, if not thousands of pages in front of the arbitration panel. 2 of the arbitrators are also fact witnesses, as they were 2 of plaintiff's abusers while she was a member of the Scientology group. So in the lawsuit Valerie was trying to bring against Scientology, 2 of the people on her arbitration panel are current Scientologists in good standing who would have been witnesses in the lawsuit itself. This is absolutely insane. Okay, during this forced religious arbitration, plaintiff was compelled to relive traumatic experiences and to disclose deeply personal information, all without the benefit of prior document review. The panel's refusal to allow plaintiff access to those documents not only obstructed her ability to prepare an adequate defense, but also highlighted the biased and prejudiced nature of the entire arbitration proceeding. I can't remember if it's going to specifically say this in what we're reading here. Valerie is not allowed to have an attorney present with her during this arbitration process. Valerie is not allowed to have any recording devices with her during this arbitration process. The only thing Scientology allows her to do is to have a pen and paper and to keep notes. And yet Scientology themselves are recording it. This is one of the unconscionable things about this total BS sham arbitration process. Because it's a religious arbitration, Scientology is allowed to make all of the rules. And it does not have to meet some legal standard of some fair and balanced and impartial arbitration, as if it was being overseen by there's some word that's usually a retired judge that's the name of the person that usually oversees an arbitration. Because it's considered religious arbitration, they can make all the rules and it doesn't matter if it's legally fair. All righty. In addition to the documents mentioned above, the committee also reviewed the contracts plaintiff had to sign. Plaintiff was forced to sign many of these documents while she was a child. During the time several of these documents were signed, plaintiff was working over 100 hours a week in what would normally be labeled as involuntary servitude. One clear example of this injustice occurred when plaintiff was a teenager and coerced into joining Scientology's Sea organization. She was also pressured to sign several so-called contracts, including the Sea organization's billion-year employment contract. Accordingly, under any other circumstances than those herein, the plaintiff would be permitted to disaffirm and cancel those documents upon the ground of incapacity. Moreover, without the authorization of plaintiff, defendants had obtained thousands of personal photographs and several videos that they had refused to return to her. These included pictures of plaintiff's childhood, engagement, wedding, honeymoon, other private and personal photos that the plaintiff never had posted to social media or given to others. The committee spent hours examining all these personal photos before putting them away again and then cruelly refusing to let plaintiff have them back. This included going through a thumb drive that contained several hours of video content of the plaintiff, some of which the plaintiff had never seen before and which she had no opportunity to review beforehand. This was all presented by the committee without any copies being provided to plaintiff. Some of these involved the many years that plaintiff had worked closely with David Miscavige and his wife, Shelley Miscavige, before she allegedly disappeared to a secret location in 2005. And so it went on and on with documents relating to the plaintiff being placed in Scientology conditions of treason, doubt, enemy liability, confusion, danger, annoyance, bad indicators, and knowledge reports submitted about her. Commendations she received, security checks, interrogations she had to endure, and fitness boards that were also convened regarding her. These are all non-arbitration terms that Scientologists use. It is important to emphasize that Scientologists can use whatever terms they wish. However, plaintiff has not been a Scientologist for at least 8 years, so she should be afforded regular court and due process rather than being subjected to the language and procedures of a religion that she is no longer a member of. As with all Sea Organization members, Scientology confiscated and held the plaintiff's passport. So the committee also dealt with an unsuccessful request that plaintiff had made in May 2016 for the return of her passport. The committee also endeavored to establish that the plaintiff's very limited access to the internet, landline, and cell phones was not heavily filtered by the Scientology Net Nanny program, restricted and monitored. But then they proceeded to show plaintiff records of each and every time she searched anything on the internet, how long she was on any given website, and every entry search she had ever performed. Oh my God, you guys. You know, one thing that I have learned through contact with people recently out of Scientology's Sea organization is that the Sea Org has been a little more permissive in granting its Sea Org members access to the internet. And at first, that might sound like, oh my God, they're giving them more freedom. Does that sound like freedom? Does that sound like freedom? The type of access the Sea Org members have to the internet is monitored and filtered in a way where they were able, and this was even back, 8-9 years ago, they were able to document to Valerie each and every time she had ever searched anything on the internet, how long she was on any given website, and every entry and search she had ever performed. That's freedom for you. Unbelievable. Okay, there were also 15 folders containing over 13,000 emails that were purportedly sent by plaintiff. The defendants had years to review these emails and other documentary information described above, while plaintiff merely had minutes. All personal communications ever made by plaintiff, to the extent there were any during her years in the cadet organization and then the Sea organization. The cadet organization was for young kids that were too young to be in the proper Sea organization. Those personal communications had been monitored and recorded by the defendants, and the committee, by examining them, proved the truth of plaintiff's litigation claims in this regard. The committee also dealt with the various documents that the plaintiff had to sign and attest to before the defendants would permit her to depart from the confines of the Sea organization. The foregoing summary is far from exhaustive. Furthermore, plaintiff has complained that the defendants, through their committee of evidence masquerading as an arbitration, had not been dealing with the allegations of her first amended complaint. For the first 3 days of forced arbitration, the committee spent over 8 hours each day trying to humiliate the plaintiff and cause her to cave in. The Scientology dictionary defines caved in as mental and or physical collapse to the extent that the individual cannot function causatively. At all times during the proceedings, there were also 2 Sea organization members in the room representing the defendants, RTC and CSI. RTC is Religious Technology Center. That's the organization David Miscavige is in charge of. CSI is Church of Scientology International, and that's considered the mother church, the managing entity of Scientology. They sat right next to the plaintiff the entire time. Plaintiff requested that her attorney also be present in the room, and every time she made this request, it was refused by the committee. The committee of evidence also brought in over 10 witnesses, which the plaintiff had zero notice of. Therefore, she was denied an opportunity to prepare for each witness. These surprise witnesses were allowed to even scream at the plaintiff, but the plaintiff could not say anything in response to any of these witnesses. The committee was not interested in the truth of what actually happened and was not even willing to allow the plaintiff to go over any of the evidence she had provided. The plaintiff was not allowed to ask a single question of any of these witnesses. She had to do so through the committee chairperson, who would then decide if and how the chairperson would ask the question. Unbelievable. In summary, the committee and the defendants, the committee and the defendants' representatives yelled at plaintiff, did not let her speak to or question witnesses, constantly called plaintiff a liar, and questioned her motives as to why she was doing this, the lawsuit, and making her conform to the committee's belief, despite the fact that plaintiff is no longer a Scientologist. In fact, plaintiff had to repeatedly remind the panel that she is not and has not been a Scientologist for at least 8 years. This was neither accepted nor acknowledged by the committee, which merely continued with the psychological and verbal abuse of the plaintiff. What is obvious is that the committee is perpetrating what Scientology has called fair game. A person who sues Scientology becomes a suppressive person who can be handled by fair game. The defendants also have a policy and practice set forth in an issue titled Counterattack Tactics, stating that those who attack Scientology are provenly suppressive. The policies this committee is using are the same tactics they have used for decades, with the sole purpose to wear the plaintiff down with endless berating, mental abuse, and delays. This is meant to exhaust both the plaintiff and the American judicial system. Part of this policy involves destroying careers of suppressive persons. These persons can always lose their jobs. These jobs, permitting them power to destroy, are valuable to them. This is a point of vulnerability if the person's job is also not valuable to him, or if he cannot be cost his job. Something can be found which he is seeking to protect, and it can be threatened. This is a quote from a Scientology issue called Counterattack Tactics. In the case at bar, the defendants are dragging this purported religious arbitration on month after month. The plaintiff has complained that the multiple 5 continuous days of arbitration interrogation herein are detrimental to her employment and to her well-being. However, the committee of evidence has insisted on at least 5 more days of continuous examination and testimony, and they have stated that they do not know when this religious arbitration will be concluded. The plaintiff has made available 5 continuous days over a weekend. I think it reads, the plaintiff has made available 5 continuous days over a weekend. As plaintiff knows, all committee members are Sea organization members who generally do not have weekends off of work. Clearly, in further of their counterattack tactics, the defendants are trying to cause the plaintiff continuing trauma, employment problems, and worse. The court should not countenance such blatant bad faith. It is time to set a date for the completion of this farce. It is insanity to me that something like this is permitted to occur within the confines and oversight of the American judicial system. In some case, it appears to be within the confines and the oversight, but it is in fact not. It's kind of like when you eat something and it goes through your digestive tract. It's not actually inside your body. It's still outside of your body, if you know what I mean. I promise you that analogy does work. Because the truth is, it looks like it's being done within the judicial system, but the judges are basically going, do whatever you want. We can't look at it. We can't see it. We can't hear it. And, it is my belief that this thing is being filed, this update, just to create a record, just because to not file it would be egregious. But I believe it is generally understood and accepted that the judge is going to see this thing and go, okay, I'll give you 5 more days. Because technically the judge has already announced that it's completely out of her hands. And I think a lot of us are sort of hopefully optimistic that something in these write-ups and these updates will be so offensive and jarring to the judge that she'll go, hold up now. I'm not willing to let this go on. Not under my watch. And it'll be interesting to see if the judge makes that decision or feels that way, how she's able to make the argument that she wasn't able to interpret whether it was fair before, but now she is. Perhaps she could make the argument that she wasn't allowed to interpret the policy, the quote unquote religious scripture. By the way, Scientologists don't actually use those words. Scientologists don't actually call L. Ron Hubbard policy scripture. They only do that when they're talking to judges and reporters. Perhaps her argument will be, I wasn't allowed to interpret your religious scripture to decide for myself whether the procedure would be fair or was capable of being fair. But I am allowed to read these updates and decide whether it is in fact fair. That is my hope. That is my hope, but that's just coming from pure optimism and not from any clear understanding of the law or what rules the judge has to abide by. Okay, so that is the update. Let's see, when is the next? Is there an actual hearing? Is there going to be a hearing on this? Boy, I don't want to make you guys sit here while I figure it out. I know that the 5 days that Scientology is requesting is like sometime in August, like May, June, July, not for a few months. I think there may be a hearing this week on this status conference. That's what's happening. There's a hearing this week, this coming next week. It's Friday. So there's a hearing next week, the status conference that was supposed to be the post-arbitration status conference and is now kind of like the midway arbitration status conference. And that is why this is being filed. It's being filed with the judge in advance of the status conference, hopefully to beg and plead the judge to intervene. Now, actually, I do notice something interesting. This request, the actual request at the end, is requesting that the judge set an end date, not asking the judge to intervene outright. I think it is generally understood that this judge is not going to do a damn thing until this arbitration is considered by Scientology to be officially completed. So the first hurdle here is to get the judge to order Scientology to complete it by a certain date. The second hurdle will be to get the judge a complete report on everything that happened and to ask the judge to throw the arbitration in the trash and to allow this lawsuit to move forward in an actual court of law. So stay tuned for that, you guys. That is all I have on this for now. Much more to come later today, guys. Thank you for hanging out with me. Thank you, as always, to everyone who watches until the very end. And I'll talk to you soon.
Okay, if you want to see my rock and roll songs, click right on this guitar. And if you want to see a different one of my videos, Oh, dancing for my love. Then you could click right inside here. If you have subscribed or not, subscribe